featuring the topic of civility, and it's featuring two of my esteemed colleagues, and allow me to introduce them. The first is Alice Woolley, who is, I must disclose, a dear friend of mine. She's a professor of law and associate dean academic at the University of Calgary. Prior to joining the faculty in 2004, Alice was a lawyer in Calgary working in areas of energy regulation and civil litigation. In 95 to 96, she was a clerk to Chief Justice Antonio Lemaire, in which capacity she lived in the cubicle across from me, and I learned from long experience that she has excellent aim with elastic band catapults. Alice is the author of Understanding Lawyers' Ethics in Canada and the co-author of, and co-editor rather, of Lawyers' Ethics and Professional Regulation. She's published papers on topics such as lawyer billing, the good character requirement, the independence of the bar, civility, legal ethics teaching, and the normative conception of the lawyer's role. She has a BA and LLB degree from the University of Toronto and an LLM from Yale. Welcome, Alice. Richard Devlin, Alice's opponent in this debate, is a professor of law at the Schulich School of Law in Dalhousie University. In 2005, he was appointed a Dalhousie University research professor, and this position was renewed in 2010. His areas of teaching include contracts, jurisprudence, legal ethics, and graduate studies. He's published widely in various journals, nationally and internationally. His recent scholarly efforts include editing Critical Disability Theory and Lawyers' Ethics and Professional Regulation. In 2003 and again in 2010, he received the Hannah and Harold Burnett Award for Excellence in Teaching First Year. In 2008, he was a recipient of the Canadian Association of Law Teachers Award for Academic Excellence. He's been involved in the design, development, and delivery of judicial education programs in Canada and abroad for more than 20 years. And in 2012, he agreed to serve as the founding president of the Canadian Association for Legal Ethics. So please welcome Mr. President. This morning's resolution is, be it resolved that it is incumbent upon the legal profession to rigorously enforce civility standards. Arguing for this proposition will be Alice Woolley. Arguing against it will be Richard Devlin. I'll turn it over to you.
Thank you, Rand. I'm delighted to be here. It's my first time in London, Ontario, so I'm getting out there in the world, expanding my horizons. And I will say some of you may be a little surprised to see me on this side of the resolution, but what happened was Richard and I were approached by Rand to debate this topic, and I said I would debate civility on the condition that I could argue in favor of it, because I'm sick of being caricatured and I'm sick of being misunderstood, and it's all about me. So this is just me working out my issues, and you get to listen to me do it. And I'm going to do, I will say with that caveat that everything I'm going to argue today, I absolutely believe in and think is consistent with everything I've written about this topic, except for one thing, and I'm not going to tell you what that thing is, you'll probably figure it out. But it's important for people to understand this issue, that you can have complex ideas all at the same time. It's, not always, but sometimes you can. And I'm going to do three things in defending this clearly correct proposition that the legal profession should rigorously enforce civility. And I'm going to start out by saying what I mean by civility. I'm going to define it. I'm going to talk about why civility is essential for effective legal practice and the fair administration of justice, and why the legal profession ought to regulate or rigorously enforce civility. And in doing this, I am going to turn on my regulatory lawyer hat and define regulation as the deliberate creation of a particular outcome. And if you want to, I can give you, Barry Barton, who I think comes and teaches here sometimes, is the source of that particular definition of regulation. So, you got to be, you're a real lawyer when you're pulling out a definition of a definition, and, that's what we like to do. In any event, civility. First thing it means is what you might call the basics of good manners or of effective interpersonal communication. So avoiding personal attacks, not denigrating people. I would like to point out to your professor, not dropping entire boxes of elastics on their heads. This would consist as inappropriately uncivil behavior, especially the person in the cubicle next to you. It doesn't necessarily preclude vulgarity. It doesn't necessarily include swearing, which is why I have to put that caveat on, because if you spend more than 5 minutes with me, you'll know that if you can't swear, you can't talk. So it doesn't mean old-fashioned manners, but it means basically treating people with decency, trying to make debates about the issue, not about the person. The second sense of civility is more substantive. And what I mean by civility there is and this is pulling from a legal philosopher called Tim Dare, who says, as a lawyer, your job is to get your clients what the law provides, not what the law can be made to give. And by incivility in this sense, I mean where a lawyer, through being obstructionist, abusive, uncooperative, and unreasonable with a counterparty, gets a result for their client simply because the other side can't take it anymore, not because it's a result that their client is actually entitled to. So that's what I mean by incivility. Being a jerk in your interpersonal communications, and number two, being such a jerk that you effectively make the other side give up. So, that's civility. Why does it matter? Well, the first argument I'm going to make can be loosely characterized as incivility is dumb. And by that I mean, let me put it to you this way. If you're a lawyer, and you all are going to be lawyers, at least for a little while, some of us for briefer periods of time than others, you're going to represent two kinds of clients, loosely speaking. You're going to represent clients who have no power, either because they don't have economic power, because their legal case is weak, because they're trying to get something done that the law doesn't necessarily let them do, or you're going to represent clients who are powerful economically, or who are powerful in terms of their legal case. Now, if you represent the first kind of client, your job is going to be to get them the outcome they want, even though nobody is necessarily required to or inclined to give it to your client. If that's the case, then going and being rude to people is very unlikely to get them to do the things that your client needs them to do. It's not going to be effectual. What you have to do as a lawyer is to try and get them to want to help your client, and the best way to do that is to treat them with some decency. If you represent the second kind of client, the powerful client, then being in civility is just really awful behavior. Because then you have power. You don't need to run around being a jerk. And if you're being a jerk, you're just being a jerk. And there's no excuse for it. There's not like this sort of advocacy behind you. You're just treating other people badly, and you're abusing the position of power that your client's case has provided to you. So either it's ineffectual or it's awful. Second reason incivility is stupid is that you focus in law school, especially in first year, on disputes. You focus on people fighting with each other, on cases where there was a problem and it was resolved by the law and there was a winner and a loser. But most of the time, the law is about allowing people to do things, about enabling them to do things, to enter into agreements with each other, to create entities, to build things that the law regulates and permits. If you're, as a lawyer, trying to get your client's stuff under the law, it's the same as representing a not powerful client. By far the best way to get your client's stuff under the law is to work cooperatively and well and effectively with others. Being rude to the person across the negotiating table, it's not going to help you get to that yes thing that you're supposed to be getting to. So that's the first thing. Incivility is stupid. The second thing about incivility is it's really mean. It's not nice to be uncivil. And when lawyers are uncivil, they are not necessarily speaking truth to power. Speaking truth to power is, yay. But often they're just being really rude to their clients, to witnesses that they're dealing with, to clerks at the court. Although when you're an articling student, you may discover that the clerks at the court are far more formidable and mean to you than you will ever be able to be to them. But nonetheless, at some point in your life, you might be able to be mean to a clerk at the court. And if you're doing that, if you have power in this world and you treat people rudely, you're just being a horrible person. So don't do that. And being a lawyer gives you power. Don't use it to be horrible. And we as lawyers should not be doing that. And one of the problems is you might say, well, yeah, but I'm speaking truth to power over here, and I'm going to be nice to people over there. Well, the problem is with ways of being in the world, it's not always easy to turn them on and off, that you can be nice to person X today and a jackass to person B tomorrow. There's a good chance you're just going to be a jackass all the time, or you're going to pick the wrong people to be a jackass to. The third argument I have about incivility is it sucks. And what I mean by that is this. There was a famous article written once called on how to be a happy, healthy, and ethical member of an unhappy, unhealthy, and unethical profession. And welcome to law. And look, you're going to go out there and you're going to work in an area of law, in an area of the world, which has a lot of challenges to it. And it is a demanding job. It's demanding in terms of the hours it imposes. It's demanding in terms of the fact that your clients often have intense and urgent needs that they need you to meet, that they may be unhappy with the situation they're in and unhappy with you for not being able to fix it for them. It's a stressful area of work. But it is made a lot more stressful if the people that you're dealing with treat you horribly. If they don't ever agree to anything, that they're just fighting with you all the time. It takes an already stressful job and it makes it just frankly almost unbearably unpleasant. And I have the virtue now of not being a lawyer but getting to live with one. And I see that in his practice. When he's dealing with a lawyer on the other side who's reasonable, everything goes relatively well. When he's not, it's just really not a pleasant life to have. So it makes being a lawyer crappy. And that matters more generally because we need to have lawyers in a civil society. And if we make being a lawyer just a fundamentally unpleasant job to have, people are going to at some point cease to wish to have it. And therefore you have to try and create a culture within the legal profession where the stresses of the profession that can't be removed remain, but the pressures that can be removed are got rid of. And I'm just going to make a little other argument in relation to this, which is that whatever complexity there might be in my views on the incivility of lawyers, to me there are no complexities on the issue of the incivility of judges. It is never excusable for a judge to treat a party at the court with contempt. It's never excusable for a judge to belittle or deride a lawyer or client appearing before them, because judges occupy a position of enormous power and prestige, and judges ought never to be uncivil to anyone. It's tempting, but they ought not to do it. But if lawyers running around being uncivil, it's much harder for judges to maintain that civility. If the lawyers who are appearing before them treat them with rudeness and contempt, it's hard for judges not to succumb to that temptation, and then you end up creating a legal system which is sort of has a corruption in it in terms of how people function. And the last point I'm going to make, and I couldn't find an amusing colloquial word to say this, but is that incivility creates injustice. And it creates injustice in a couple of ways. One is that if you look at the cases from the Law Society on civility, you will find that in a number of them, the lawyer who was uncivil had a practice which could politely be described as a train wreck. And the incivility was the kind of canary in that particular coal mine. Their rudeness to the various people they were dealing with was a symptom or associated with an underlying problem in their practice. And of course that problem was creating injuries to their client and also to third parties that they were involved with. And the other issue, and this is I think really significant, is that if lawyers are abusive enough, they can get the other side to fold, particularly if the other side is self-represented, and that is an increasingly common feature of our legal profession. And if people are folding on claims that they have because the other person they're dealing with is so rude and objectionable and offensive, the reality of that is going to be that you have a diminution in the availability of justice. And that's not something that we should tolerate. So, that's why incivility is terrible. Now let me talk about the legal profession's enforcement of it. The first thing I would say is that in this course, I'm sure you're spending lots of time talking about law society discipline and things that the law society does and how we regulate and what we regulate, et cetera, et cetera. Law societies are only one form and probably the least significant form of regulation. If you want to know how lawyers are going to behave, what you need to do is look at how the lawyers in a particular community behave and what are viewed as acceptable and non-acceptable practices within that legal community. And what you will see is that where practices are viewed as unacceptable, that lawyer tends to suffer social consequences for engaging in them, the old-fashioned shaming and shunning that we as humans like to engage in with each other. And that sounds awful, but at the same time, if people are engaged in the kind of practices that I described here, it's appropriate for a culture to try and reduce or eliminate those behaviors through the ordinary mechanisms of human interaction. also known as I won't work with that asshole. And the second thing I would say is that if we believe truly that civility is important, then you have to leave some role for a regulator of a legal profession to try and create that outcome, whatever way that they can. And as well to say, it's not enough to say, look, if you have all these things, it creates issues of competence and problems in the legal profession, but also to go on to say, and we as a regulator won't permit that to happen. And there are better and worse ways that you can do it, but it certainly behoves the legal profession to try.
So Professor Woolley promised me she was going to be funny.
So
I guess it's up to me to try and be serious and funny at the same time. So let me start by thanking Professor Graham for inviting me to participate in this debate with Professor Woolley. And it's my great pleasure to be at Western. But I want to start by saying that this debate is rigged. It's rigged in two ways. First of all, Alice Woolley is, quote unquote, a dear friend. Right, of Brian Graham. And secondly, Professor Woolley is the proud daughter of middle-class English parents. She is a true blue blood. And I am not that. Right? I am from Ireland. I grew up in Belfast. I come from the ghetto. And we all swear like troopers. So this is clearly a rigged debate. And not only that, we're having this debate at the University of Western Ontario, the most preppy law school in the country. So the outcome is foregone in this debate. Who's going to win? So if that's the case, I think we've been an uphill struggle. So let me just sort of start by sort of commenting on Professor Woolley's presentation, which I have not seen before and heard this morning. And I could describe her presentation in a number of ways. I could say it's analytically flawed. Is that okay as a form of critique? I could say it is superficial. Is that okay? I could say it is platitudinous. Don't be stupid, don't mean, it sucks, don't treat people badly. Right? It's just stuff. Am I crossing the line of civility there? Might I be able to say it was a woolly-headed argument? Is that crossing the line of civility? Because sarcasm doesn't work. Could I say it's a draconian argument, as some judges of the Supreme Court of Canada call all the judges? Right? Could I say it's poppycock? Right. Or just bullshit. Right. So where is that line of civility? So I want you to think about where we draw that line. And so to make my argument, I want to move in sort of 6 points I think I want to make. But the general argument is as follows. Of course, as any rational person, I think civility is both a public good and a private virtue. But Professor Woolley, like every zealot I know, takes the argument too far. Like other members of the so-called civility movement, and it is a movement, all right? It's based on groupthink, right? It portrays civility as a dangerous carcinogen sort of infecting the body of the profession. And I suggest that they're provoking a moral panic far beyond the necessity that it entails. So to make those points, I want to sort of develop 6 short arguments. The first is the indeterminacy argument. That is, while of course there are some behaviours that are clearly uncivil, maybe some things I just did, right? There's also a large number of behaviours that you can't easily classify as either civil or uncivil. It's indeterminate, it's penumbral. So last night, for example, when we were having a few drinks, we spent a good hour debating what constitutes a swear word. And we did not get consensus. One person even thought the word dick was a swear word. Not in Ireland. Right? Moreover, in an increasingly diverse society such as Canada, a society that's very pluralistic, civility norms are highly contextual and potentially subjective. To the extent that the demographics of the legal profession are increasingly reflecting that cultural diversity, civility may be an inappropriate regulatory mechanism because it is so culturally specific, so English in so many ways. So take, for example, Professor Woolley's argument. Start off with a fairly narrow definition of incivility. but by the end it was anything that's abusive. So it's this capacious idea that actually sort of may suck in too many things. The second concern with civility I'm going to describe as lessons from history. Legal historians have demonstrated how in the past the norms and expectations of civility have been used to exclude or discipline outsiders to the legal profession. Women, members of the Jewish community, other members of minority groups. The concern is that the current emphasis on civility may unconsciously reproduce these elitist and exclusionary practices, and they will have a disparate impact upon particular subcommunities in the legal profession. So in this case, in this sense, the Joseph Groya case is the exception. Normally in civility charges are not brought against high-end securities lawyers, they're brought against lawyers in small firms and sole practitioners. So it has a disparate impact on certain members of the legal profession. Thirdly, I want to argue that civility in fact may be a threat to lawyers' ethics. And as you all know, lawyers have three primary obligations. The first is a duty to their clients. The second is a duty to promote the administration of justice. And the third is an obligation of integrity. An undue emphasis on civility is a threat to these three core obligations. First of all, sometimes to advance a client's legal interests, resolute advocacy does require a lawyer to be forceful, perhaps even rude or impolite. That's part of our role morality as lawyers. As the trial judge said in Briex, litigation is not a tea party with scones on a Saturday afternoon in England. Right. Secondly, sometimes in the pursuit of the advancement of the administration of justice, a lawyer has to be unvarnished in their criticisms of other lawyers and also of judges sometimes. The invocation of incivility in these circumstances can generate the unintended consequence of lawyer protectionism. And thirdly, if lawyers are to behave with integrity, they might often have to take stands that are unpopular in the face of those who have power. That will lead others to label them as uncivil. In other words, I'm suggesting that an undue emphasis on civility can have a chilling effect on lawyers' ethics. And it may in fact even be a threat to the independence of the bar. Fourthly, civility norms and rules are redundant. When you actually review the cases where law societies have disciplined for incivility, the cases reveal that there are several other grounds for disciplining lawyers beyond civility. Whether it's breach of one's duty of law to a client or bringing the administration of justice into disrepute. Civility, therefore, is just a make-weight argument. It serves little practical purpose. Its role is simply rhetorical and symbolic. It obscures, rather than illuminates, the precise nature of the problematic behavior by the lawyer. The fifth argument I'll describe as misplaced energy and resources. And there's a number of regulators in the room today, and this is pertinent particularly to their view of the world. Even if incivility is a problem, I argue that it's unwise to pour so much energy and resources into this problem. The Canadian legal system has fundamental problems today. Issues around the competency of lawyers, but more importantly, issues around access to justice. And the regulators are putting a lot of energy into this whole debate around civility, and there are literally hundreds of thousands, if not millions of Canadians who need real help. Instead, we're having these little debates about civility. Did you cross the line, did you not? So, it seems to me that it's these other issues, access to justice issues, that are the real drivers for bringing the legal profession into disrepute in the eyes of the general public. Not a little bit of incivility by lawyers. That's why we're not a popular profession, not some concerns about incivility. And my sixth and final argument is a forum argument. A large amount of the problematic incivility tends to happen in the courtroom. I want to argue the proper forum for dealing with lawyerly misconduct should be in the court, not in some ex post facto law society discipline hearing where you've got no context. Right? It is the judge in the courtroom who sees the context of the alleged incivility. And it is the judge who has the legitimate authority and the power to police lawyers who are officers of the court. Law societies are simply the wrong forum for working this through. So I want to thank Professor Woolley for giving me this opportunity to demonstrate the fallacious nature of her argument.
Well, my first response to that is, to the extent the debate is weighted in my favor, I need all the help I can get against this guy, so I'll take it. No, I would like to say actually that to me the least offensive thing said by my friend there was that my argument was bullshit, but that maybe says something about my own roots, since I don't think that profanity is any less common on my aisle than on yours. But that leads me to my main response here to my learned friend, which is the fact that a decision requires a certain level of judgment does not mean that it is an impossible decision to make. If that were the case, then we as lawyers might as well fold up our tents and go home. That we don't necessarily have a sense of perfect precision as to what civility is and incivility is does not give us an excuse for not trying to come up with a compelling answer to that question. Anything else is to embrace a kind of radical subjectivity, which I think is inconsistent with our mandate as a system of laws in a legal profession. And to the extent incivility regulation has been directed at a particular segment of the bar, well, that's just a problem of regulation in general. All of our regulatory activities are directed at a particular segment of the bar. And whether that's a problem of the regulation or a problem of that segment of the bar is an argument that some of us have had. But either way, it's not a particularly telling critique of civility discipline itself. And at the end of the day, it may be that I am trying to create a moral panic. Perhaps, in this case, a moral panic is what is required to allow us to pay true attention to the seriousness of this issue for the legal profession.
So I'll just make three sort of brief responses. My learned friend. Note the sarcasm. Right. Is that not incivility? That's supposed to manifest? Think about back in high school, guys. Right? Were there not people in your class, or perhaps even in law school, who are very civil people, very polite, but they are the nastiest creatures you can imagine? Right? So just think about that. So we got not mistake form for substance. Professor Woolley's argument is really a form for substance argument. I guess the second point I would make is Professor Woolley's argument around, well, yeah, perhaps it's a problem just regulating the lower end lawyers. But I will make, and this is a sort of a Rand Graham argument, let's do a law and economics analysis of this. Right? Law societies have finite resources. There's no doubt about that. Right? So are they going to put all the resources into running after a few people for incivility? Or should we actually focus on what the real issues are? We can't solve all the problems, so instead of sort of expanding the civility police, so they're running around everywhere, right? Just take it off the agenda. Get to the real problems of the legal profession. Not this, as I say, superficial sort of public relations exercise, because that's all we're doing here. We're trying to make ourselves look good in the eyes of the general public, when perhaps we're actually rotten to the core.